Now, to help us understand this issue further, we have a legal authority on the show. We have Attorney Domingo Cayosa, former president of the Integrated Bar of the Philippines. Welcome to Morning Matters, Attorney.
Good morning. Magandang umaga po sa lahat.
Okay. Ano po ang inyong pagbabasa dito sa decision? So, narinig po natin yung panig ni Attorney Salpanero, narinig po natin yung panig ni Attorney Dino De Leon. The other one saying that the acquittal is null and void, and the other one saying that there is no reversal of the acquittal decision. How do you read this?
But it's very clear in the Court of Appeals decision na null and void daw yung decision ng RTC acquitting former Senator De Lima dahil hindi in-specify kung anong portion ng testimonya ni Ragos ang na-recant at anong epekto nito, anong fact ang hindi na-prove dahil ito. So, and that is why sabi ng Court of Appeals, grave abuse of discretion daw yung ginawa ng RTC. At pag grave abuse of discretion nga naman yan, necessarily as stated in decision na null and void daw yung kanyang decision. But the decision of the Court of Appeals, hindi pa naman ho yan pinat. Pwede pang i-appeal naman this time ng akusado sa Supreme Court. So, ang final arbiter whether or not there is grave abuse of discretion, yung...
Do you think there needs to be a retrial to be able to determine the missing facts in this case? Or is it just a rewriting of the decision by Judge Alcantara?
I don't think there's any need for a retrial because testimonies have already been heard, documents have been submitted. It's just the requirement of the Constitution and the rules of court that if a judge decides, he should clearly state the facts and the evidence and the law upon which it is based. So you cannot just make general declarations in your decision. Correct. Because due process and the law requires, you have to specifically point out what are those things that guide you or concern you inside that.
Oo, pero if in case the judge does not have the facts on hand, in case the judge made a hasty decision to conclude that because there was a recantation of the star witness that this case has no basis, therefore an acquittal happened, pag wala yung mga facts na yon, could there be a continuation of the trial?
That's precisely what the Court of Appeals ordered the regional trial court to do. One is, sa the records, tignan mo, Judge, kung saan ba dyan yung recantation, ano bang particular portion ng recantation ang nakaka-epekto dun sa krimen. Kasi yung testimony naman, mahaba yan eh. But the more relevant and material things are those that would prove the elements of the crime. So the judge has to point out why he thinks this particular element of the crime was not proven because of the recantation. Kasi pwede rin po naman na kahit mag-recant isang witness, kung meron namang sapat na ebidensya dun sa mga natitirang mga dokumento o kaya testimonya ng hindi nag-recant, and it can be proven beyond reasonable doubt, pwede pa naman mag-acquit. So it's now for the judge siguro to look into this. There's no necessity for a new trial or a retrial. There's no ground. Susuruin lang niya at explain lang niya, i-particularize niya kung ano yung basehan dun sa kanyang pag-acquit.
Speaking of finding the right evidence, what is needed in order to prove threats and intimidation? Where Rafael Ragos said that he was threatened, he was intimidated. Enough na po ba that he testified on the witness stand? Is that or would you need proof of intimidation?
You have to show proof of intimidation, and it's not only simple intimidation. It should be an intimidation or a threat that compels you, or you have no other choice but to sign the affidavit. Kasi nga, naglipa na sa ating sa ating mga kaso, yung mga binabaliktad nila ang sarili nila for flimsy reasons. So pag sinabi mo na threatened ka, kaya mo pinirmahan niya, you have to prove how you were threatened. Kasi nga, you signed that under oath before an administering officer. So the jurisprudence also is recantations are frowned upon. Because, the fact that it was before an administering officer, ang sinasabi nyo, pati yung administering officer, kasabwat dun sa pananakot sa iyo. So you have to explain. Hindi pwedeng sabihin, ay nakalimutan ko, hindi ko naintindihan, o kaya natakot ako, period. Hindi na. Because very sacred yung under oath dapat. Sa ibang bansa, talagang hindi basta-basta na nababawi yan. Dito lang po sa atin kasi nauso yan konting recantation lang, kaagad akala natin wala nang saysay yung kanyang sinabi. You have to prove very convincingly yung mga factors that vitiated your consent. Ibig sabihin, ayaw mo sanang gawin pero wala kang magagawa because nanganganib ang buhay mo at talagang forced to good ka na gawin yun. Nagtestigo pa mga ito. In-confirm nila ng una. So,
pero attorney, Attorney, in case hard evidence is not or could not be produced by Rafael Ragos, what does that do to his testimony overall in his first affidavit, where he implicated Leila de Lima, and in his second, where he recanted? If he's not able to produce hard evidence, how do we see him? Where do we find him in this whole picture?
Well, the trial court will have to weigh yung dalawa. But what is clear is in so many cases decided by the Supreme Court, recantations are frowned upon. Kasi napakadaling sabing tinakot ako And it is not good policy that we allow people to come up with statements under oath and then later on, a few days, a few years down the line, biglang sabihin na lang, ay hindi yan totoo. They have to be held accountable. As a matter of fact, pag ganyan ang ginagawa mo, 2 beses kang magsaka under oath, you can be liable for perjury because either way, if there's a conflict, hindi ka nagsabi ng totoo dun sa isa. That's the legal effect as far as Ragos is concerned. Doon ako naman sa korte, they'll have to ask questions. They have to probe deeper to be convinced na talagang pinilit nga siya noon. Siguro, anong klaseng threat ba yan? Diba? So, they have to look into this much deeper. They should look into this much deeper para makumbinsin ang lahat na talaga namang napilitan siya.
Attorney Cayosa, if a decision is declared null and void, is it like pag sinabi po nating ang isang kasal ay null and void, therefore it does not exist in the first place, does it apply in the same way here when we talk about the principle against double jeopardy?
Well, of course, if it is null and void right from the very beginning, as if there was no decision. So, if the decision of the Court of Appeals finding that the trial court acted in grave abuse of discretion, pag ganun ho kasi ang finding, walang kabase-basehan o kaya dinisregard yung mga requirements ng batas tungkol sa desisyon ng mga ganyan, ang ibig sabihin nun, null and void. So, it retroacts as if there's no decision at all. Mabubura yun. But of course, ang final say dito, yung Supreme Court. Most
okay.
The defense will elevate it to the Supreme Court.
But before that, dito lang po sa Court of Appeals, the principle against double jeopardy or of double jeopardy rather does not apply because the decision was declared null and void. Tama po.
Yes. How can you have double jeopardy kung wala namang decision in the first place?
Alright, okay. Maraming salamat po sa pagpapaliwanag ng ating case before us. We have Attorney Domingo Cayosa former president of the Integrated Bar of the Philippines.